Everybody, and thank you for joining us today. You're all very welcome to this online conference on the UN War Crimes Commission. For those of you who don't already know me, my name is Amina Adnan. I'm a lecturer in Maynooth University Law Department, and I research in the area of universal jurisdiction and the history of international law. As you can see from the programme and conference materials, we have a really interesting range of presentations today. We have lawyers, historians, political scientists who are covering such a wide range of topics related to the UN War Crimes Commission. In addition, we have a really impressive lineup of distinguished speakers who are here to share their experience and knowledge with us. And we have participants who've registered from all over the world. So no doubt we will have an exciting and enriching day ahead, which I'm really excited about and I look forward to. This conference is organised as part of a small project on the UN War Crimes Commission that's funded by the Royal Irish Academy, for which I am the lead principal investigator. The project began in May and is coming to an end this month. So one of the aims of this project is to foster international collaboration between scholars working on the topic of the UN War Crimes Commission, and it's part of that aim that this event takes place. So as you know, the UN War Crimes Commission, which operated from 1943 to 48, facilitated a network of tribunals that operated on a national level after the Second World War. So here, 16 Allied states came together and prosecuted persons who committed international crimes during that period. Yet the UN War Crimes Commission is sometimes overlooked in terms of its importance, notwithstanding that there were well over 2,000 trials that took place. And since 2017, the UN War Crimes Commission archives have been made available to the public online, in particular due to the efforts of Professor Dan Plesch, who is here with us today, in persuading the relevant persons to unseal the archives. So as such, there is ample opportunity for research on the archives, yet at the same time, in comparison to other historic international criminal law legal institutions, the UN War Crimes Commission remains somewhat understudied, although I have to say that judging on the attendance and registration numbers here today and the response to the call for presenters that we've had, I'm seriously questioning whether the UN War Crimes Commission is in fact understudied these days. So as our programme today shows, there are scholars working on this topic from all over the globe. So this event today aims to bring together scholars researching on the UN War Crimes Commission. So my own research on the UN War Crimes Commission focuses on the exercise of universal jurisdiction under the institution. And this is a topic that I'll present on this morning, and it's one of the themes of today as well. So the last panel of the day is on universal jurisdiction, on lessons from the past and current application. And that panel will be chaired by Barrister Leonard Paulson, with contributions from leading practitioners and scholars in the field. So I look forward to that later. The conference today is an opportunity to network and to share research ideas and to get feedback on your work. And to facilitate networking, I would encourage you all to keep your videos on and to ensure that your name on Zoom is your real name. You can, of course, edit your name on Zoom by just clicking on your image and clicking on the 3 dots that appear in the corner. I would also encourage you to participate actively in the conference, to ask questions to presenters and to share your feedback and comments. So just a few housekeeping points before I hand over to Dan. So first of all, the panel sessions will take place in breakout rooms. So if you have not already communicated your preference in terms of the panels for the morning and the afternoon session, if you're attending either or both of those sessions, you can send me a private message stating the panels that you prefer as soon as possible. all attendees will be moved to their selected panels or breakout rooms during lunch or the break times, the coffee break times. So please don't log out of the Zoom call during those periods, because that's the time when you'll be moved into your respective panel. This conference is recorded, and the recordings will be made available on the conference webpage after the event. Please ensure that your microphone is on mute when scholars are presenting, and for anybody who is presenting, you will be able to share your screen if you want to use a PowerPoint or a Prezi or etc. Tool for your presentation, and you can share your screen just by clicking the Share Screen tab at the icon at the bottom of the Zoom page there. So now I'm going to hand over to Professor Dan Plesch to give his welcome address.
Thank you very much. I really want to express my gratitude to you, Amina, in thinking of initiating, raising funds for and leading this project. I'm also, I think, slightly overwhelmed at, I wouldn't say finally, but the amount and quality of the presentations, the widespread interest in attending is I think fantastic, and I'm really looking forward to the intellectual engagement today. I can say we, on behalf of both of us, I think that we invite further interest and collaboration in exploring the work and research, and as far as they're available, you know, you're welcome to pick my brains, such as they are, all of you as panelists and attendees in the period ahead. I'm also delighted that my colleagues from Chambers, Leonard Poulsen and others from the London circuit and so on, are bringing in the perspective of the working barrister, and if ever there was evidence of the importance of interdisciplinary, multidisciplinary research, I think that today's conference and lineup demonstrates the value of interdisciplinarity and the engagement of practitioners and academics in a unified process. And that I think also is something we can take away and perhaps talk to our bosses about its value. A couple of other quick points. We did announce that we would give prizes to the best student presentations, and we will do this, and we'll get back to the lucky people. Sorry, not lucky, it won't be luck, it'll be careful judgment by Christmas. Just to say, if there are one or two people out there wondering about that. I have opportunities later on to give my 2 cents about this whole business and additional ideas. I guess personally, the concept that I developed with Amitav Acharya and others, I call the restorative archaeology of knowledge, which perhaps is a rather sort of, it's intended to be academic clickbait, I suppose, to be crude. But archaeologists' words appeals both to IR theorists and devotees of Michel Foucault, but also to the historical side. And there is, I think, a welcome trend. We see it in racial issues, notably, of rediscovering past realities that have been suppressed. And my own work on the UNWCC arises from a broader research agenda in the lost, radical and effective work, particularly in the 1940s, which we can draw on to revitalize multilateralism today. And just this week, we have been launching a new book on suppressed histories of the dominant influence of Southern women in the development of women policy in the United Nations. So from my perspective, this is part of a broad reappraisal of the international system and drawing upon lost wisdoms, of which UNWCC is clearly one. So that's all I have to say by way of introduction, and now I can pass the baton back to Amina to give us her keynote opening address on the issue closest to her mind and heart of universal jurisdiction. Amina, the floor is yours, as they say.
Thank you, Dan. I'm just going to share my slides with everybody. Okay. So the title of this presentation is The Exercise of Universal Jurisdiction During the Operation of the UN War Crimes Commission. This research is based on research that I'm working on at the moment under this project. And it's work that I've been conducting with the help of Aisling Gormley, who is a research assistant on the project. And she's also an LLM candidate in the International Justice Programme at Maynooth University Law Department. So for anybody who is not aware, the principle of universal jurisdiction allows any state to prosecute an accused person who is accused of committing an international crime. It doesn't matter what their nationality is, nor does it matter where the crime occurred or what the nationality of the victims is. So in theory, it's a very wide-reaching principle. One of the things to note about the reliance on universal jurisdiction during the UN War Crimes Commission is that it was very much a subsidiary form of jurisdiction. It wasn't relied on as much as other types of jurisdiction were, such as the territorial principle or the passive personality principle, which were a lot more common during the operation of the UN War Crimes Commission. So just to make that clear. So prior to the Second World War, there was no state practice in the exercise of universal jurisdiction over international crimes within the modern meaning of international crimes. So crimes such as war crimes, crimes against humanity, and genocide, and for a variety of reasons. Before the UN War Crimes Commission was established, it was already clear that the belligerent states during war had the right to punish enemy nationals who committed war crimes against their own nationals. So, but that again is very much based on the passive personality principle as opposed to universal jurisdiction. And you see reference to the undoubted right of belligerents under international law to try enemy nationals for war crimes committed against their own nationals. You see reference to this throughout the materials of the UN War Crimes Commission itself. However, the principle of universal jurisdiction, or universal repression as it was then termed, was written about by leading international scholars at the time. So this list would include the likes of Raphael Lemkin, Vaspian Pella, Emil Rappaport, and Henri Dondieu-Devabre as well. And when they wrote about universal jurisdiction or universal repression, they argued that it applied to a specific set of offences, which they termed to be crimes against the law of nations. And in addition to that, when they spoke of universal repression, they were talking about what we now would call the principle to prosecute or extradite, or the obligation to extradite or prosecute an individual, whereby the accused person is in the territory of a state, and that state either prosecutes the individual or extradites them to another country to stand trial. So in this research, I argued that the UN War Crimes Commission provides the first examples of universal jurisdiction being exercised over international crimes in the modern meaning of the word, and thus this is worth exploring. So looking to the legal basis for the exercise of universal jurisdiction under the UN War Crimes Commission. So first and foremost, it's well known that Control Council Law number 10 set out the foundational jurisdiction for the tribunals that took place under the heading of the institution. And firstly, Control Council Law number 10 set out that member states had the jurisdiction to punish any person without regard to nationality within its zone of occupation. Second, it set out the crimes that came under the jurisdiction of the UN War Crimes Commission. So these, of course, were war crimes, crimes against humanity, crimes against peace, and membership of a hostile organization. Control Council Law 10 did not grant jurisdiction to the member states to try offences committed by German nationals against other German nationals or against stateless persons. Although as the institution progressed, in particular the US national military tribunals, there is evidence of the US national military tribunals prosecuting crimes committed by German nationals against German nationals. And as was stated in the US case of Flick, the US national military tribunals believed that it was at the discretion of each occupying power as to whether crimes committed by German nationals against German nationals could be punished in a German court within that zone of occupation. But where no such German court existed, then the US National Military Tribunal reasoned that it was on that basis that non-German tribunals, such as military tribunals, could conduct the prosecution. Now, member states were given much autonomy as to how they incorporated Control Council Law into number 10 into their legal framework. So not all states implemented the full scope of Control Council Law number 10 into either their laws or into their practice. And I'm sure as everybody is aware that the practice of UN War Crimes Commission was not uniform for a start, and very much depended on the interests of the priorities of each member state. In terms of the justifications or the rationale cited within the UN War Crimes Commission materials as to the basis on which universal jurisdiction was being exercised, this heavy reliance on reference to a well-known article by a judge advocate general from the US Army, a man called Willard B. Cowles, who wrote or published an article on universality of jurisdiction over war crimes. And he published that in the Californian Law Review in 1945. And in it, he goes through the principle of universal jurisdiction. He professes its existence, and it's that article that you see referenced time and time again in the trials of some of the member states where they used universal jurisdiction and they're trying to justify it. And you also see it in the UN War Crimes Commission materials as well. So in his article, Willard B. Cowles talks about the general doctrine called universality of jurisdiction over war crimes, under which every independent state has in international law jurisdiction to punish pirates and war criminals in its custody, regardless of the nationality of the victims or the place where the offence was committed. In addition to that justification for reliance on the principle, you also see reference to what is known as the representation principle or representative principle. And you see reference to the fact that any state has a direct interest in punishing the perpetrators of a crime where the victim is a national of an ally. Here you have states who are, or the rationale is that any state can prosecute an accused person who is infringed on an ally's interests. So this is another justification for reliance on extraterritorial jurisdiction under the UN War Crimes Commission. So looking to the state practice over the individual crimes, starting with war crimes, war crime and the practice of universal jurisdiction under the UN War Crimes Commission. War crimes was by far the most common international crime prosecuted under universal jurisdiction. Again, practice, as I said, was not uniform, so it's very hard to identify kind of common threads between all of the member states' practice. But you do see common threads within individual member states' practice. So examples of states that provided for universal jurisdiction over war crimes in their law were states such as Australia, Canada, the US, the UK. In terms of the acts that were punished as war crimes, again under universal jurisdiction that I've looked at, commonly the acts were murder, ill treatment, torture, inhumane treatment. Less commonly, you see acts such as attempted murder, rape, the war crime of systematic terrorism, and destruction of towns and villages as well, to a lesser extent. The victims were soldiers, in this context, particularly prisoners of war of other nations, and civilians who were in camps, detained in camps, or not detained in camps as well. So moving to state practice in relation to the exercise of universal jurisdiction over crimes against humanity. So of course, as I'm sure you're all aware, Control Council Law number 10 severed the nexus between crimes against humanity and international war that existed at the time. The justification for that was because CCL number 10 was viewed as domestic law as opposed to being international law. However, notwithstanding that, some allied states, but not all, criminalized crimes against humanity in their laws implementing Control Council Law number 10. So examples of countries that did incorporate that principle or universal jurisdiction over crimes against humanity were countries such as Poland, the Netherlands, the US, and China. In practice, very few states prosecuted crimes against humanity under universal jurisdiction. And when they did prosecute the crime, the war nexus remained. So it was crimes against humanity committed during wartime that were prosecuted as opposed to during peace. There is some very minimal evidence of universal jurisdiction being exercised over other crimes. So there's minimal examples of prosecutions of genocide under universal jurisdiction before the US tribunals, so the US National Military Tribunals. So it's very hard to kind of state that there was a definitive kind of a principle there, but there is some minimal examples all right there. One-time chairperson of the UN War Crimes Commission, Lord Wright, acknowledged in his commentary on the tribunals the connection between genocide and universality. So citing Lemkin's work, he says that genocide has become delictium juris gentium alongside offences such as piracy, trade in women and children, etc. In terms of other crimes that were subject to universal jurisdiction, so the US and the Chinese military tribunals did enact laws allowing for universal jurisdiction to be exercised over crimes against peace, or what we now call the crime of aggression. But I haven't come across any practice of that just yet, but it was criminalized in their laws. So just to conclude, what can we definitively say about the scope of the principle of universal jurisdiction under the institution of the UN War Crimes Commission? So the first thing to note is that there's definitive evidence of universal jurisdiction exercised over war crimes. Obviously, at the time, war crimes and the concept of war crimes was very much linked to an international armed conflict. And to a lesser extent, there is evidence of universal jurisdiction being exercised over crimes against humanity. And even to a lesser extent after that, some minimal examples of the principle being exercised over genocide. It is clear that universal jurisdiction, as relied on by the institution, was a subsidiary form of jurisdiction. The other forms of jurisdiction, excuse me, such as the territorial principle and the passive personality principle, were much more commonly relied on. It is also clear that universal jurisdiction in absentia, so where the accused is not present in the prosecuting state for trial, that in universal jurisdiction in absentia was not intended. You see that in the laws of the member states. You also see that in the language of Control Council Law number 10, and nor was it practiced either. And there's a definite link there when the member states exercised universal jurisdiction over enemy nationals. There's a definite link there to this concept of kind of allyship between the members, the allies of the member states of the UN War Crimes Commission, and how when a state is relying on universality of jurisdiction, they are doing so on behalf of their allies against the enemy. And you also see heavy influence on the scholarly, or reference to scholarly writings for justifying relying on the principle. And particularly you see reference to Willard Cowell's article time and time again throughout the materials, as well as Raphael Lemkin's work as well. So I leave it there. I'd like to thank you all for listening to the opening presentation, and I welcome your comments and feedback on this work. This is work in progress, so I'm keen to get any feedback that you might have on it. And if you do have feedback, you might let me know maybe during the discussion, some of the discussion periods throughout the day. Okay, so thank you very much. So now I think we're going to move on to our keynote panel. We have a fantastic lineup of speakers for the keynote panel today. So I'm just going to bear with me a moment while I introduce everybody. Yeah. Okay. So the first of our distinguished keynote speakers is Dr. Julia Eichenberg, who is Senior Lecturer and Research Fellow at the University of Beirut in Germany. So previously, Dr. Eichenberg was a Freigeist Fellow at the Department of History in Humboldt University in Berlin, and she has held fellowships in Trinity College Dublin, in University College Dublin, and at the Centre Mark Bloch Berlin, and she has also lectured in modern European history at Trinity and in UCD in Dublin, as well as in other reputable universities. Julia has published on topics such as paramilitary violence, pacifism, veterans' welfare, and international collaboration. Her first book on Polish veterans of the First World War, their struggle for social benefits and national recognition, was published in 2011. Dr. Eichenberg's current research project, The London Movement, explores the transnational collaboration of governments in exile in London during the Second World War and its impact on European political communications in the 20th century. So with great pleasure, I introduce Julia to give her keynote address. Thank you, Julia.
Thank you so much for the kind invitation and introduction. And first and foremost, I would like to congratulate the organizers on this truly interdisciplinary and international conference. And I was very impressed by the lineup, and I'm really looking forward to discussions today. So thank you for organizing this. And as you said, I'm here as a historian, and the research project, The London Moment, is still running. It's funded by the Volkswagen Foundation. It moved from Berlin to Bayreuth and engages with wartime London as a hub of exiles of different nationalities. And I'm currently concluding the book on the collaboration of the European governments in exile. And maybe interesting in this regard, I also recently co-edited a special issue on the historic positioning of the UNWCC together with Kerstin von Lingen and Sabina Perhat-Begovic. And some of you present here today were also involved in the preceding discussions. And so this will be published with the Journal of the History of International Law in early 2020. I can't see myself anymore, but I'm just going to continue. I hope you can hear me. So today I want to discuss the prehistory of the UNWCC, looking at the London International Assembly, the LIA, and show that and why London wartime discussions provided a greenhouse for this debate and the development of thoughts on international law. Building up, of course, by publications by Dan Plesch and others. My aim is to scrutinize, if you will, the black box of discussions preceding the UNWCC and to explain its origins in pan-European allied discussions that have, in a way, been overshadowed by a very strong Anglo-American narrative that has been installed in post-war historiography. So the LIA was an allied wartime organization based in London, initiated by and organized under the umbrella of the British League of Nations Union. And its members belonged to two partly overlapping groups. So firstly, a circle of European governments in exile, and secondly, allied internationalist continental Europeans, but also international. I will focus on the European part today. And I argue that the LIA and collaboration here not only paved the way for the UNWCC, but it's influenced its further development on how to discuss these topics in three ways, I argue. So firstly, it introduced transnational collaboration, and in particular, the transfer of legal knowledge as an essential mode of operation. So the LIA collaboration and transfer was planned and pushed by allied European exiles in London, with significant input from comparatively smaller or maybe politically less dominant countries, such as the Benelux countries, Eastern European allies. In London, they gained influence because of their standing as cooperative allies due to, for example, their contributions in finance, such as the colonial powers, Belgium and the Netherlands, also Norway, not colonial, but financially well off, their contributions to information and knowledge, for example, Poland, or in resistance, for example, Czechoslovakia, and this could be discussed in more detail. But accordingly, they could use the LIA to feature their own plans of post-war security and introduce their politicians and academic experts as protagonists from early on. And within this context, European legal experts were well situated and very close to their own governments because, and I think this is very important, because law was a focal point of surviving in exile for these people. So individual European refugees fought for their own legal status, but also national committees struggled to be recognized as exile governments. And so legitimacy was a precondition to agency within the allied universe. Legal questions about sovereignty and democratic representation, but also about legislative, executive, and judiciary were central to everyday life in this universe. And this put legal experts and advisors in very prominent position within the exile governments and laid a foundation for a substantial collaboration in other areas of international law, such as the prosecution of war crimes. Then secondly, looking at the LIA discussions gives us insights in who was involved in creating, transferring, and implementing legal knowledge. The LIA was structured as an assembly, almost like a parliament, and members had to be national representatives. And it linked back to a broader allied microcosm in London, different governments in exile, but also a variety of legal platforms and institutions, some with long traditions, such as the International Law Association, and then others that were newly funded during the war, such as the Cambridge International Commission for Penal Reconstruction and Development. Additionally, the exiles were in close contact, and their British and American partners or other international partners were in close contacts to think tanks like the Royal Institute of International Affairs, today known as Chatham House. Again, this allows us to broaden our focus and include protagonists from different European countries, not only European, but in my context, European. And so we have a whole group of what Michael Madsen described as legal entrepreneurs, and I found this phrase quite fitting. So we have Frenchmen like Cassin and Pin, and the Dutch like De Moor and Zeeman, and the Czechoslovaks Eche, Schwelb, Terowski, the Polish Glauser and Lux, or Belgium Choffen and De Beer, and they all frequented these platforms and each other very regularly, as well as their British contacts, in particular in the Foreign Office, for example, Malkin and Beckett. So the LIA thus includes this universe of exiles, of advisors, think tanks, spanning East and Western European countries, and even beyond. And it even allows us to include the question of gender in an otherwise predominantly male sphere. And we can detect less brokers in these wartime networks, which otherwise might have remained invisible, as so often in international and legal history, as historians like Landis Luger and Marion Röwekamp and Katharina Rietzler have pointed out. And one example that I will further go into is Dr. Ethel John Lindgren Utsi, who's a Swedish woman with a PhD in anthropology who worked at the Royal Institute for International Affairs, so at Chatham House, and who worked as a liaison officer between Chatham House and the Allies governments in exile, as well as the liaison between the Allied governments and the London International Assembly. And she was very essential in organizing support for this collaboration, very material ways, like opening the doors of the Chatham House Library for Allied researchers and organizing lecture series to enable exchange on certain topics. By the way, in the regard of this gender question, since you encouraged networking, if anyone has further information on the women representatives at the UNWCC, I would be very much interested. So maybe we get back to this. And then thirdly, my third point would be that looking at the LIA opens legal debate to a history of quite successful networking, implementing and framing of political problems as a first but essential step to later achievements. I mean, one could argue that the LIA and their European members were not completely successful in implementing their concepts and were eventually overshadowed by Lemkin and Jackson. But to my mind, this is secondary. To my mind, it doesn't matter that they did not provide all these solutions, but central is that they introduced the questions and thus defined the problems, framing, to use Goffman's term, framing the future discussions on war crimes. And this is based on an understanding of international law as both a frame of reference and a tool that, to my mind, dominates London discussion. And to put this into practice, LIA operated with technical commissions. And of course, the most famous amongst them is the Commission on the Trial of War Crimes, but it wasn't the only one. And this commission members, there were 37, and as an exception to LIA rules, they also included guests from Germany and Austria. So they discussed the current state of law in the member countries in comparison to existing international law, and they assigned academic reports to the respective representatives of the current situation to identify gaps and loopholes which needed to be filled. And these were then gathered in the LIA reports by the Commission on the Trial of War Crimes and in other declarations. And one of the most important aims of the Commission is stated as to impress the governments of the United Nations with the necessity of instituting, without further delay, an international body for the study of this question. And in doing so, you know, seeing the UNWCC at the end, they were quite successful. In going there, to make up for their lack of political weight, the exile governments adopted strategies of a legal discourse of legitimacy and sovereignty, but also a very dedicated PR campaign. And the LIA, I argue, followed this example to propagate their aims, including the trial of war crimes. So in very important steps, such as the Inter-Allied St. James Declaration of 1942, in BBC broadcasts, in public talks and special publications, and of course the 1943 LIA reports on punishment of war crimes, they raised publicity for their agenda and introduced a narrative of how to prosecute war crimes in the future. And they furthered a constant recourse to the failure of war crimes, of the war crime trials in Leipzig, and fed into a very dominant never again narrative, which in general was at the center of the LIA work. And so from early on, this led to a regular collection of information on transgressions of law, of atrocities, of war crimes, and thus creating an extensive source material, which would later be used to fall back on. I hold this brief, I try to hold this brief now, so summing up my argument, linking academic and political spheres, the LIA expert commissions managed to engage with the legal challenges of this endeavor, discussing questions of extraterritoriality, retroactive law, and the fact that these crimes committed were crimes of a new kind. And it shows that these discussions laid a foundation for the work of the UNWCC, and even if you will, they were not mentioned prominently in the end credits. And I leave it for the discussion to go into more detail. Thank you.
Thank you very much for that exciting introduction to the keynote panel, Julia. So now I'm going to move on to our next keynote panelist. So our next keynote panelist is Dr. Mark Ellis. Dr. Mark Ellis is Executive Director of the International Bar Association, which is the world's foremost international organization of bar associations, law firms, and individual lawyers. Dr. Ellis is an expert on international criminal law, and he has researched widely on the UN War Crimes Commission. He has served as legal advisor to the Independent International Commission on Kosovo, chaired by Justice Richard J. Goldstone, and he was appointed by the OSCE to advise on the creation of Serbia's War Crimes Tribunal. He was actively involved in the Iraqi High Tribunal and the extraordinary chambers in the courts of Cambodia, as well as in the Kosovo Special Chamber as well. In 2013, Dr. Ellis was admitted to the list of assistants to counsel of the International Criminal Court, and in 2015, he was appointed as chair of the UN created advisory panel on matters relating to defense counsel of the mechanism for the International Criminal Tribunals, which of course oversees the remaining cases for the ICTY and the ICTR. So without further ado, it gives me great pleasure to welcome back Mark to this event today.
Amina, thanks so much, and thanks so much for your leadership in this project. It's really extraordinary that we have an opportunity to come back and continue to look and discuss this really fascinating area regarding the War Crimes Commission, and I want to also thank Dan. I'm not sure there's anybody in the world that has done more to put the UNWCC in the public space than Dan Plesh. His legacy is now firm in the work that he's done. So I'm indebted to him. I've only been given we only have 10 minutes because we have lots of great speakers. So I'll keep mine to the 10 minutes. And I just wanted to touch on. There's so many issues we could talk about, but I wanted to just talk and touch on three that I think are really fascinating when we look at the work of the commission. And that is, well, Julia was just talking about kind of pre-UNWCC and what transpired to help create that. I'm going to talk a little bit about how the UNWCC had an impact on the Nuremberg Charter. Then I'm going to talk a little bit about the relationship and the ICC. This is something Amina had talked about in the sense of looking at the Commission for Universal Jurisdiction, but we can do the same thing when we talk about some of the basic principles of the ICC. It's quite extraordinary to look at this path, this journey that was started with the Commission. And finally, something I have a real interest in is the fair trial rights, because of course, it's one thing to talk about the work of the Commission and the national offices. If you can't say that these were fair trials, then really the legacy of the process, I think, is in doubt. And I know later on in one of our breakout sessions, I think Dan is chairing a session that has that discussion. So I won't spend a lot of time on that. But let me just say a few words and to remind everyone that actually when you look at the Commission and you can say, well, it really was an incubator in the early days of kind of substantial and procedural materials, legal concepts that deal with international criminal law. And when you look at some of the substantive issues on that, it's really fascinating to look back at the history and the documents, to look at for instance, the discussions that were held at the level of the Commission during its creation, and certainly in the autumn of 1944 concerning the crime of aggression. So, can you have a crime specific to an aggressive policy of a state? And this is really fascinating because it was debated back and forth with the delegates who attended and who were part of the discussions. And it really, after the debate, there just came a general agreement that at least in the waging of a war of aggression, that certainly constituted a war crime. But we also know, and this is the interaction between the Commission and the work of the drafters of the London Agreement, and of course, moving into the Nuremberg Charter, that after the work of the commissions, including this substantive discussion on the crime of aggression, which is, of course, as we know, came into the London Charter, you have evidence that Justice Jackson and his colleagues reached out and started having this dialogue with the Commission. We don't know, based on the history, exactly how close that connection was, but we do know that the drafters of the London Agreement and the Commission did meet. They interacted, they discussed, and prior to opening of the major war crimes criminals at Nuremberg, the Commission was really in close touch with the staff of Jackson, and both particularly with prosecutors from the United States and Britain. We know that there's evidence in the documents showing that they met. We know that that Jackson attended meetings of the Commission. We know that the Commission had made it very clear that before and during the trials that the Secretariat of the Commission was urged to create these relationships, these dialogues with Jackson and his staff, and so that comes out pretty clear on this. There is also a lot of procedural cooperation between the Commission and Jackson. We see that. And that there was an effort to create this kind of mutual cooperation between staff at the Commission and Jackson's staff as well. And I say the chairman of the Commission appealed, and this is in writing, appealed to all of its members to do all that they could to assist Justice Jackson and his colleagues to help kind of build a picture and what would be kind of the total pattern of the war crimes that had been committed, because of course the Commission had that information. So I think that the one can say that largely owing to the Commission's work, that some of the substantive laws and procedural laws that came into the Nuremberg Charter was because of the work of the Commission and the collaboration that existed. We know also that the reports, when you read the reports of the London Agreement, we know that the Commission had a role in that. We know that the Commission members had the opportunity to examine some of the provisions of the London Agreement and put forth some suggestions. So we know that interaction occurred as well. So I think that's really important to continue to see this path. Again, as Julia was talking about, coming into the Commission, and now we see where the Commission is moving it onwards to have an impact on the London Agreement and the Charter itself. So I think that's important. Now, getting to this really fascinating area of seeing what the Commission did in setting out standards that exist today. And again, Amina talking about universal jurisdiction, really remarkable information about that concept and that principle playing such an important role within the Commission. But the same thing can be said about the International Criminal Court. And this is really fascinating to me, and particularly the issue of the principle of complementarity for those that have studied and know much about the Rome Statute. We know that the Moscow Declaration with the Commission had at its heart the primary jurisdiction to try war criminals was at the national level. We know that, and that was evident. But one of the things that's really fascinating is the Commission, there was a bifurcated debate about this. And we look at it, this really was a precursor, I think, to the current structure of the ICC, because under the ICC, the Rome Statute, again, says that the national courts, the ones that have the primary jurisdiction to undertake these trials, and only if they're unwilling or unable to do so will the ICC take this responsibility. But we know also in the Moscow Declaration, there was discussion about the creation of an international court, and the international court was there and suggested to take on the trials of the major more prominent figures. This is what the Commission said: the judging of a certain, be it limited number of the most prominent criminals, such as Hitler, Himmler, Göring, Mussolini, etc., could take place much better by an international criminal court than any national court of law. And this is really interesting because when you look at the Rome Statute, that's exactly how the Rome Statute is structured. The recognition that it is better and more efficient and probably legally stronger to have this bifurcated approach. Of course, we didn't see an international criminal court emerge at that time, but certainly later on we did. So from the earliest stage of the drafting of the Rome Statute, knowingly or unknowingly, the precedent of the Commission was established, and the ICC's approach to serious crimes, approach to the principle of complementarity absolutely mirrors the approach that the Commission took in its deliberations and its relationship with national offices. The second subcategory of this is really interesting, and this deals with the International Court for the former Yugoslavia. It was the practice, of course, as we know, with the national office submitting cases to the Commission, and the Commission would then look at these cases and determine if there's kind of prima facie evidence of a war crime, and if so, there was justification to apprehend and prosecute the accused at the national level. The Commission didn't bother with making kind of binding decisions on the Allied powers with very minor war criminals, but on others they did. And this mirrors something called the rules of the road in that came out of the ICTY and what could be seen as national parties within the former Yugoslavia. So Serbia, Croatia, Bosnia-Herzegovina, Macedonia, all had to, in essence, collaborate with the Hague court in determining whether or not they could take cases on their own. And this is called rules of the road. And it required the Hague court to say, yes, prima facie evidence exists, and you can go forward with it. So again, a fascinating area of mirroring what the commission had been doing and what future international courts would undertake. My final remark is on the fair trial, because I think this is, again, one of the most important areas. We know that the documents show that 24,760 persons were tried in Europe and in the Far East, between 45 and 48. Of those, 71% were imprisoned, 8% were sentenced to death. So this means 79% of those charged were convicted and 21% were acquitted. So if you take that as your base number, I think then you must ask, should ask ourselves, well, what was the fairness of the trials at that, based on those kind of numbers? I had published an article back when Dan had put together the first conference on this, and he invited a number of us to draft articles, and I did one for him that really focused on this issue of fair trials. And so I spent a lot of time looking at the documents of hundreds of cases to see whether or not I felt that the fair trial standards were met. And of course, you had to determine whether fair trial standards measurements at that time are the same as it would today. I went back with a colleague of mine 2 years ago, back to the National Archives in the United States and also in the British National Archives, and decided to take a look at some additional cases. Took 28 cases from the 809 cases that were from the law reports of the commission, and then did an assessment on those 28 cases. And I looked at some of the fundamental areas. I looked at the right for an independent, impartial tribunal. I think that was exceedingly important. The presumption of innocence, fair trial, public hearings. I looked at whether the right to legal counsel had sufficient time to prepare for a defense, the right to an interpreter, and the principles of the evaluation of evidence, the right to appeal. And those are the areas that we looked at. We don't have time to look at all of the conclusions, but that I felt were some of the fundamental areas where you could say that fair trial rights under customary international law would be consistent then and would be consistent now. And generally, I found, with some exceptions, I have to say, and particularly this presumption of innocence, and the United States took a very aggressive position on this, trying to influence the courts kind of emotionally. In the Cohn case, the prosecution saying during the last 10 or 15 years, hasn't it been a common trait among German people as a whole to be easily influenced and to commit crimes? And this was really interesting to see these types of, within the US setting, these types of comments time and time again. But overall, when I looked at all of those components of what I thought would be consistent with stating that yes or no, fair trial standards were met, I wanted to come to some type of conclusion based on this new assessment on the trials. And the new assessments I've come as it says, well, was this really victor's justice in relations to fair trial rights? And generally, I conclude that it was not. Largely no, that when you look at these standards and you look at all the case files, and the case files weren't, in the archives, I couldn't, some case files were had a deeper background than others. Some were not a lot there, but generally I would say when we looked at all of those case files, my overall assessment was that fair trial standards based on those standards were in fact met. I think there's a lot of room to continue on that, and I hope we can continue to do that. So that's a good result for the commission, I think, and yet again shows what the Commission did and how it influences on today's area of international law. So Amina, thank you very much.
Thank you very much for that excellent keynote speech, Mark. Lots to think about there, and especially in terms of again, what we can learn from the UN War Crimes Commission in terms of international criminal law today. So thank you very much for that. So our next keynote speaker is Professor Dan Plesch. So Professor Plesch is Director of the Centre for International Studies and Diplomacy at SOAS in the University of London. Professor Plesch is the leading scholar in the UN War Crimes Commission and has published widely on this topic. Professor Plesch has significant expertise in navigating and researching the UN War Crimes Commission archives. And as I've already mentioned, he was instrumental in persuading the UN to release the archives to the public in 2017. In addition to that, he is one of the few academics that had access to the files before they were made publicly available. Professor Plesch is the author of numerous books and articles on the UN War Crimes Commission and related matters, including Human Rights After Hitler, the Lost History of Prosecuting Axis War Criminals. So I'll hand over to Dan now when you're ready. Dan, I think you're on mute.
Silly me. I already have many thoughts and questions from the contributions we've already heard. And as I say, unfolding is a fascinating day. I want to speak in my minutes to 4 points. How come we have a UN body before San Francisco? What this might mean, what this means for Holocaust-related studies. Some comments on the politics of the period and references today. And from that, fourthly, into implications for future policy in the area of complementarity and research with respect and research more generally. So to begin, much overlooked, there was a declaration by United Nations on January the 1st, 1942, which I've written about, which actually is the world's first treaty on including provisions on human rights. It includes the Atlantic Charter. Many years into my research, I was giving an exhibition at the UN in Geneva, and the archivist wheeled in a huge ledger, Harry Potter style, of treaties lodged at the League of Nations. And there, in copperplate ink, they recorded that the British had lodged this declaration as a treaty in 1943. It does not appear in any modern studies as a treaty. And a colleague of mine, Chide, has done a little more work on this. And I think it's a small area of important research. So this is how, and I've written quite extensively on this, how the UN existed before the San Francisco conference, which itself, we talk of COP26. San Francisco was in fact the UNCIO, the UN Conference on International Organization, but few, if any, historians of San Francisco ever used that formal title, which is a question for historians and historiography, I think. So that's my first point. The second point I want to make is the implications for Holocaust studies. And this material, but not least the material collected by the Commission in London before liberation, is an outstanding record, because this data was brought to London very largely by people who collected this data under pain of death. It was either smuggled out or the individuals themselves escaped to London with this material. It includes, and subsequently, it includes data which I think shows new light on a whole range of Nazi crimes and practices. And I'd be very keen to find partners to further develop and evaluate this research. I mean, just to take one tiny example, there's a former German political prisoner in the American army who provides new evidence about the fate of the Jews in the Greek islands, where the Orthodox story is that they were shipped to Auschwitz. Well, he records how, in fact, a number of them were sent out to sea and then simply drowned by the boats being scuttled. And there are many other examples of shedding light on the practice of crimes, but also it provides a different type of evidence of Nazi crimes, which one might say broadly is Nazi confessions or documents thereof themselves, which were used extensively at Nuremberg, very effectively, forensic material evidence, witness testimony. Now, but this provides a contemporaneous set of very widespread legal documents, not necessarily trial records, but for example, there are a large number of Netherlands trial reports, which Netherlands scholars haven't used, and which some colleagues there find to be remarkable in the detailing of the occupation. And I find it's slightly odd, but hopefully we can change this, that a number of countries in Europe couldn't make extensive use of this work. So I'll stop there on that point. But I think it's something which potentially there's a great deal of room for partnership in a creative way. And it does itself provide a further rebuttal to Holocaust denial, of course, a different type of evidence, legal evidence of indictments from that period. But the third point I want to make is to do with some of the political dimensions. Of course, one of the reasons why the London International Assembly was in business was because although the exile governments had lobbied hard for legal remedy on war crimes, at least from the St. James's Declaration of January 42, and in October of 42, there had been an Anglo-American statement that there would be a UN commission to investigate war crimes. Because of political opposition within the British American governments, it never happened for another 12 months. And that was, in order to maintain momentum, how the LIA came into being. A further example, and I don't think one can tell this story without recognizing a very upper-class hero, Herbert Pell, father of the famous senator, who had been sent by FDR as his ambassador on war crimes to London, and was sacked by the State Department 6 weeks before the liberation of Auschwitz for pursuing the issue of crimes against humanity. On my website, you'll see the document that he proposed in the Commission on Crimes Against Humanity, far more extensive and broad than the definition subsequently adopted in the Charter, and on the issue of an international criminal court. And he and his British counterpart were forced out at the end of 44. But Pell, took upon himself to make a vast row in public, which I document. And without his activism, I personally find it hard to see the agency in Washington that propelled the Truman administration to call on Justice Jackson to go to London. And I think this is much overlooked, and there should be office blocks of law schools for him, and also for his mentor Sheldon Gluck, who also was Ben Ferencz's mentor on this issue. And Gluck was a member of the London National Assembly, but notably, I think the Brits boycotted it, if I remember rightly. So that's a thumbnail sketch on some of the political dynamics leading to the future. And of course, Pell, according to an early biography, wrote to a friend that, yes, we were going to win this war, but we had to make sure that the Nazis were held accountable, and that the post-war period, there wasn't a Nazi revival in which the Gestapo officers talked about the joys of looting France and shooting Jews. And that his imperative was, and this is perhaps somewhat chilling and modern, his imperative, he said, was to ensure that there was no Nazi revival, the way in which the Confederacy had managed a revival in the United States. And given that we now see people marching around with Confederate and Nazi flags, it is a real warning. And just as Adolf Hitler said on the eve of the Polish invasion, don't worry about what we're going to do, no one remembers the Armenians. So too, we have to be careful to remember, lest we repeat the horrors of that time. My final remarks, I just want to move into the area of complementarity and future-orientated research. There is, I think, a great opportunity for American scholars to draw upon the full trial transcripts, which we have available on our site, of the US military tribunals of the period. Now, the US Judge Advocate General University has shown no interest in this, and its official history skates over its wartime role as Judge Advocate General. But you have hundreds, as Mark has carried out important research in this area, but it beats me why at this stage you haven't got a leading American law school with a significant program drawing upon the work of these military commissions. Similarly, I think that there is an opportunity within the European Union, which sees itself as having a leading role in global governance and justice, to draw upon the actions of its own member states in international criminal law in this period. Julia and other speakers today, I think, will talk about this, but it is a real missed opportunity, I think, for the European Union to draw upon its very notable history. And as Julia says, this has somewhat been obscured by Anglo-American narratives. More broadly, though, with my colleague Leo Owen now at Swansea, we have an article coming out in Humanity, which further develops, I think, the idea of how UNWCC practices in the area of complementarity provide examples, solutions, benchmarks for a more extensive support for national and regional international criminal justice endeavors than currently exist. Because we have, much better than not, we have gloriously the ICC, but concentrating on a few top cases. And the UNWCC provides a set of models and benchmarks in terms of peer review, in terms of advisory opinion on legal matters, in fair trial procedures, the use of, and one can look at, for example, customary legal practices in Rwanda, the Gacaca court, so one can look at the mobile military courts currently going on, or which went on in Central Africa through MONUSCO, and a project which brings together the scattered efforts at complementary justice at a national level, sees the need for them at a global level, and perhaps can persuade some of the leading participants in the UNWCC that they should draw upon their historical record to do this. And it is, before closing, worth noting, of course, that a number of skeptics of international criminal law today, notably China and India, had very important roles in the development of international criminal law at this time. And I think particularly for China, few people stop to ask, how did China end up on the Security Council, given the racial politics of the West? Well, yes, because the Chinese had fought hard. Yes, because Roosevelt wanted China to balance a future Japan, but also because the Chinese nationalist government, much derided, had pursued a policy of legitimating itself through international law before and during the Second World War. And the emphasis on international legal standards is by the Chinese government is, I think, particularly important to discuss given relations and developments in China today. So forgive me if I've gone over time and if I've been rather too scattershot in my remarks, but I just wanted to draw to you some of the issues, particularly in my mind, as we go into this fascinating conference. So thank you very much.
Thank you very much for that really insightful keynote speech, Dan. Lots of really interesting points there. So thank you very much for that. So our last keynote speaker is Dr. Anne-Sophie Schoffel, who is a historian in Ludwig Maximilians University in Munich. Dr. Schoffel was a historian of international law and a professor in history at the Sciences Po in Paris, and also a visiting fellow at Harvard University. She completed 2 PhDs in the University of Heidelberg and Lorraine University. Her first PhD examined for the first time the Saigon war crimes trials in Indochina, and the secondary examined the Tokyo trial through the lens of colonialism and recreation of the liberal world order. Dr. Schofffel's research focuses on the history of international law, humanitarianism, migration, and memory, and her work has been published in peer-reviewed journals and edited volumes. While at Harvard, she completed her new monograph on the imperial origins of international law in the French Empire and the Global South. So without further ado, I hand over to Anne-Sophie. You're very welcome.
So thanks so much for the invitation, and yeah, it's a true honor to be invited as a key speaker today. So let me start with 2 questions. So my 2 questions are: how did a group of French refugee legal scholars and diplomats obtain international support during World War II for investigating Axis war crimes at the height of World War II? How did Free France contribute to establishing the basis of a new world order? I'm going to answer these questions in my short keynote address. So those questions really triggered me when I first saw the recommendations of René Cassin to participate at the separate Far Eastern Subcommission of the United Nations War Crime Commission in the wartime capital of the Republic of China, Chongqing. René Cassin pressed Free France to get involved in the subcommission, saying that, first, the crimes committed by the Japanese against French citizens, subject and protégés, must be examined and punished. Second, the Chinese people who suffered would appreciate any gesture of solidarity for France. And third, the Chinese people could be useful. The report, addressed on May 9, 1944, to the French exile government, was contained in a dusty archival box at the French National Archives in a particularly interesting file. This file was composed of a photography of 3 French exiled and lawyers in Chongqing, a ceremony organized on the Bastille Day, press reports about the French participation at the UNWCC in the Chinese press, radio broadcasts from Radio India, and spy activities in French Indochina. This file was telling me the French involvement at the United Nations War Crimes Commission was not just about law, it was about visions of world order and imperial legitimacy. So we know the importance of the United Nations War Crimes Commission as a landmark in the history of humanitarian law. We have seen that with the 3 last keynote speech. And this conference really highlighted how from 1943 to 1948, the UNWCC investigated and recorded allegations of war crimes, identified war criminals, and assisted national governments in the preparation of trials. The historiography highlights that the UNWCC stood as an answer to Axis politics of destruction and established an early modern of wartime and post-war multilateral cooperation. So Julia Eichenberg just digs into the wonderful work of the London International Assembly. Dr. Ellis reveals the importance of the UNWCC, not only for the Nuremberg trial, but also for the London International Assembly, and also the question of the fairness of the trial. And Dan Plesch has also highlighted the importance of the historical records, the work of the UNWCC for the codification of crimes against humanity, and also the political dimension of the UNWCC. The history I would like now to investigate is an alternate history. Delving into a world-spanning legal agency, histories of exiled diplomats and lawyers, I think we should also see the UNWCC as a place where imperial powers defended the vision of an imperial liberal order. One that reached across the global territories of the mandate system administered by the League of Nations into the colonial empires of the French, British, and Dutch empires. And during my presentation, drawing upon newly unsealed UN and French archival materials, I would like shortly to document here Free France intervention at the UNWCC, because it tells us another story on the UNWCC, a story on empire, race, and international law. During World War II, so Free France and a handful of jurists and politicians worked day and night to both establish the imperial sovereignty of the French Exile Committee of the General de Gaulle in London and in Chongqing, but also to restore French republicanism. At the UNWCC, Free France addressed not only key questions of international criminal law, especially the one concerning conspiracy, but as they also presented to the Commission dossiers and charges against Japanese and German individuals. The UNWCC also led the legal foundation of the Free French machinery to apprehend, bring to trial, and prosecute war criminals. It's also important that when we look at the history of World War II, when we look at Free France in June 1940, when it was established at the beginning of World War II, it started really from scratch, as Professor René Cassin suggested. It was only a government in exile. 4 years later, on October 1944, the service, the war crimes, the French war crimes unit was created in Paris. And this was permitted through the work of the UNWCC and the participation of two delegates in London. It is René Cassin and André Gros. And René Cassin, interestingly, from London, translated the UNWCC recommendations to frame an investigating war crime system adapted not only to France, but also to its empire to prosecute war crimes. So in Chongqing, it's important to know that the Free French delegates contributed to establishing diplomatic legitimacy, seeking to justify imperialism in the post-war world. But it was very difficult for them to get integrated because China officially granted recognition to Free French agents in Chongqing only after 1943. And also Free France had only limited resources and a small number of qualified staff. So the consequence of this precarious situation was a perpetual change of delegates at the subcommission. And so there were, from November 1944 to March 1947, there were Achille Clarac, Jean Daridan, Montous, Jean Bretès, Éric Pelin, and Michel Bertin, which turned in investigating allegations of war crimes committed in Asia. But what is the most important? And here it's the main point of my talk, is that French UNWCC representatives belonged to the new generation of French jurists who emerged from the defeat of the Third Republic in June 1940. Their visions for the eventual restoration of Republican democracy and their involvement in the international prosecution of war crimes intertwined with larger allied plans for post-war Europe and crucially for the reordering of the world. At the UNWCC, they made their names synonymous with the Republican cause and the international world order promoted at the League of Nations. But it's important to know also that their approach to international law, sovereignty, and geographies was still maintain a powerful hold over the legal imagination of them, and especially a vision which was entangled in the world vision and established at the 1885 Congo Conference in Berlin. So all the French representatives all defended at the UNWCC the existence of a French empire. And as Hannah Arendt has argued, from the interwar period to the aftermath of World War II, global governance and international relations were strictly tied to colonialism. And my last point here is about how did they perceive law. So they perceived they had a double standard in the legal treatment of French nationals and the protégés of France, civilized of Europe, civilized people of Europe, and in the indigenous population. So understanding this double standard in the French imperial jurisprudence also reconcile an apparent conflict on some UNWCC members, countries like Belgium, France, the Netherlands, and the United Kingdom, who on the one hand express their determination to civilize international law, and on the other, to reinvigorate their colonial empires in Asia and Africa. Those countries believed in the world order promoted at the Paris Peace Conference, where the legal order has been extended to protect also the indigenous peoples. Guillaume Mouralis had also demonstrated that the UNWCC representative André Gros had his humanitarian concerns were close to the imperial internationalism embodied by South African Marshal Jan Smuts. So it means that Joe refused to subordinate atrocities to a conspiracy to wage an aggressive war, since this opposed French colonial interests in Algeria, where there was a quasi-racial legal segregation. And Jay Winter also revealed that René Cassin thinking on war crimes and human rights was awash with contradictions, since he considered treating non-Europeans, Palestinians, and Muslim Algerians differently from Europeans with respect to their rights. So men of his generation adopted all at the UNWCC, so for the French case, a double standards when dealing with human rights violation. And what is also interesting is that the internationalist and imperial position of the French representative really fractured in May 1945 when it came to violent conflicts over French sovereignty in Algeria and the French mandate, symbolized by the massacre of Sin City in May 1945, or the bombing of Damascus also in the same May, in the month of May 1945. So what we can really see is that like Belgium, the Netherlands, and the United Kingdom, France's imperial jurisprudence was really based on a double standard when it faced human rights violations, but also war crimes and prosecution. And let me finish this presentation also to show how the imperial world order continued during the war to exert a profound hold upon the imagination of free French agents. So when I looked at the files on the UNWCC at the French National Archives in Paris, there was also a central figure. This central figure is diplomat Maurice Dejean. So he was at the interline meetings, and he always tried to promote the legal authority of free France and also of its empire. But when we really looked at his approach on international law, we can really see that it was really based by political objectives. And he presented his government as the model of humanitarianism. And this was very important to present France as free France as a humanitarian power, and to defend it as for the cultural, to assert the cultural diplomacy of France. But interestingly, so after the war, so first he was an ambassador in Czechoslovakia, then he was nominated in Japan, and he always promoted internationalism and humanitarianism. But interestingly, in 1953, in the height of the First Indochina War between France and the Viet Minh, so in Vietnam, so this man Maurice Dejean was nominated High Commissioner for Indochina, and he was encouraged to use the use of napalm to fight against the Viet Minh during this bitter war of decolonization. So here we can really see through his lens that the that the participation of the French and also of the British, the Belgium and the Dutch power at the UNWCC must be reframed in another lens, and to also highlight those questions of empires and also races. So thank you for your attention.
Thank you very much, Anne-Sophie, for that really insightful presentation. So thank you very much for that. So now I'm conscious that we've gone over time. The presentations were all just so interesting. It was hard to stop them. So what I'm going to do now is I want to open the floor to for discussion for maybe about, I'd say, maximum 15 minutes. So if anybody has any questions or wants to raise any points with any of the keynote speakers, you can just maybe raise your hand virtually on Zoom, or you can pop your question or comment in the meeting chat and I'll see it there. The other thing I was going to say is that if any of the keynote speakers themselves want to pick up on any points that they want to elaborate on, either that they themselves brought up or maybe another panelist brought up, please do share your thoughts. Julia, I can see you have your hand up there.
I could just, from the sources I looked at, I could completely confirm what Anne-Sophie talked about in terms of the issues of race and the post-war order. So all the LIA discussions that you can find, you know, there's always a lot of talk about human rights and about the right of sovereignty for all the states, but it always concerns a Western world, and in colonial empires are never touched upon. And also maybe to give further reasons for this, because they were the backbone of what these exiled countries still had. They were, their European home countries were occupied, and they could still fall back on their colonial empires, which they did, and they drew finances and resources from there. So they never ever questioned their colonial empires and wanted to keep them. So I just wanted to confirm Anne-Sophie's point. It's very interesting. Thank you.
Thank you, Julia. Okay, just to reiterate, does anybody have any questions for any of our panelists on their presentations?
I might just make a quick point, if I might. I very much appreciate the Anne-Sophie's remarks, and I think this theme is comes through the work at Heidelberg with Kirsten von Lingen. It's an interesting and powerful dynamic, but what of course we've ended up with in the world is that the dynamic that the occupied countries used to try to bring the Nazis to account and redress the Nazi approach, they then found themselves having to adopt with respect to, or were forced to adopt with respect to their own colonial practices, not necessarily from choice. And you can go back to the initiatives from Franklin Roosevelt in this respect, in terms of self-determination, of letting the cat out of the bag, if you like. And you can see in Nelson Mandela's memoir the importance of the Atlantic Charter as a clarion call, and one sees that in the way in which Roosevelt insisted that India have an independent voice in all the wartime conferences, as if it were Australia. Few people stop to ask, what is India? How is India, the Indian female ambassador in 1946, doing there denouncing South Africa when India doesn't become independent for another 12 months, for another year? And the answer is because of Roosevelt's initiative. And that dynamic, the anti-imperial nature of a left democratic president and his constituents is an important push in this, which again tends not to be remembered by people who want to be critical of America or a more conservative American consensus that then emerged. And there's also, of course, the Chinese dynamic where they were, as I say, looking to liberate themselves from colonialism, and in fact got rid of the foreign enclaves in China in 1943. So these contestations are very real, and I think what Anne-Sophie has emphasized is extremely important. And of course, in some respects, it continues to this day. And even in that time, there's the infamous remark of Henry Stimson against crimes against humanity, because it would get in the way of American lynching of Black people.
Thanks, Dan. Mark, I see you have your hand up there.
Yeah, I think it should be also emphasized again on something, Amine, that your topic on universal jurisdiction, and the reason is because this bridge between what the Commission's work was about and current international law is really so fascinating, and is, I think, often missed by even scholars and practitioners today. But the universal jurisdiction one debate is a live debate right now in the international community as to whether or not this more absolute form of universal jurisdiction is now fading, and conditionality is being forced upon this whole principle by in state practice. And so I think this is so important for the community to understand, well, how did universal jurisdiction emerge? Were the debates, how it was used? And that gives us a real good sense of why this issue is so important. So I wanted to re-emphasize that, Amina, in your work.
Thanks, Mark. And actually, just a couple of points on that. One of the things that I noticed in my research generally, not just in relation to this project, is that like obviously, the nexus between only, like, if you look to the practice of universal jurisdiction after the Second World War in the UN War Crimes Commission, keeping the nexus between international armed conflict and international crimes, i.e. war crimes or crimes against humanity, it shields the allies from being open to being prosecuted for the very same acts that were committed in their colonies and in their territories. And that's something that I know Twale scholars such as Anthony Angie and others have commented on, that you don't see the removal of the nexus between crimes against humanity and international armed conflict until colonization has largely come to an end. And just on Sophie, just on your presentation there on the role of imperialism and race in particularly in the French involvement in the UN War Crimes Commission, just reminded me of something I came across in my research on looking at the laws of universal jurisdiction under the UN War Crimes Commission. And one of the references I came across in the US National Military Tribunal in Guam was that its tribunals could I have it written down here, could prosecute persons who committed crimes against US nationals or any white person whose nationality had not been established. So I thought that was very interesting to see that written into a US order that authorized the prosecution of international crimes in Guam after the Second World War. So and even if you see look to the locations where the Allies set up their commissions or tribunals outside of Europe. So the US had some military tribunals in the Philippines. The Dutch had some military tribunals in Indonesia. So you have this link between the establishment of these courts by the Allies in countries that they were historically linked to due to colonization. So you definitely see that theme even in my work as well. So I just wanted to make that point there.
I think Anne-Sophia also on that, what her great points on that also, I mean, it leads to this whole issue that exists today, that there is a difference between powerful states that can create barriers, structures to avoid prosecution, escape prosecution, and this is seen in universal jurisdictions. It's seen in the ICC. It's seen in lots of different places where there's again a difference between